Morning. I acknowledge the Gadigal people of the Eora Nation, the traditional custodians of this land, and pay my respects to the elders past, present and emerging. I hope you and your family are all safe and well. We are glad that we could go ahead this morning in a different way than we had planned to provide you and your organisation with the support and learning you want. My team do look forward to talking to you over the coming weeks, at least to just say hi. Over the coming weeks, as we work differently and remotely, it will be important that we all say hi to our staff and each other. Discrimination is a big and growing area, even in 2020. This is despite over 40 years of such laws. It is one of the go-to areas for disgruntled employees. The law in this area may also be changing with the Religious Discrimination Bill, and that will present many challenges for employers. And yes, sadly, discrimination still occurs in the workplace. Somewhat overshadowed by recent events, there was the Australian Human Rights Commission National Inquiry into Sexual Harassment with its final report released a couple of weeks ago. We have two speakers today who are keen to talk to you about the hot topics on discrimination, Amber Sharp and Jade Bond. I hope you enjoy our webinar today, and I do look forward to your feedback and hearing from you. Thank you very much. Amber.
Thank you very much, James. Good morning and welcome to our brave new remote world. I would like to pay a special tribute to those of my colleagues who are brave enough to be sitting in the room with me to give me a bit of moral support in these difficult times. But echoing James's comments, I do hope that you and your families are well. All right, so I'm going to kick off today. We're doing a bit of a tag team, Jade and I. I'm going to be talking about religious discrimination. All right, what are we going to talk about? The infamous Religious Discrimination Bill. I'm going to talk about the equally infamous Israel Folau case. Then Jade is going to have a chat about the sexual harassment report, criminal record discrimination, and a bit of a where to from here. Sorry, I've just got syncing issues with my laptop and so I'm going to keep an eye on these slides. There we go. Easy. That's all right, we've worked it out, everybody. Thank you. Sorry, a few teething issues. All right, so let's talk about a little bit of history. You may recall the Marriage Equality Postal Survey. I do. I don't recall it fondly. It basically sparked a religious freedom review. As part of that, we also had the unfolding saga in relation to the Izzy Folau tweets. Issues arising from that saga were also fed into the Religious Freedom Review. Coming out of that, we now have a package of proposed legislative reforms, and did you see I smiled a little bit then when I said reforms? In any event, the package comprises the Religious Discrimination Bill, the Religious Discrimination Consequential Amendments Bill, and the Human Rights Legislation Amendment Freedom of Religion Bill 2019. What is it actually all about? Well, the Religious Discrimination Bill is about prohibiting discrimination on the ground of religious belief or activity in key areas of public life. And so in many respects, what it is seeking to do is replicate other forms of prohibited grounds of discrimination. However, as will emerge while we go through this process, there are some provisions that I will describe as unconventional, which many pundits are suggesting are taking it too far. But why don't we have a chat about the famous Izzy Folau case? I suspect everybody knows who Izzy Folau is, but just in case you're not a rugby nut, Izzy was a professional, well actually now as it transpires remains, professional rugby union player. He formerly played for the New South Wales Waratahs and Australian Wallabies. He also previously played AFL and NRL. Importantly, for the purposes of our discussion, he describes himself as a devout Christian. So, this was basically what happened, as I understand it. Izzy posts a tweet. I think we've got one of the, I'll call them offending tweets up there. His employer has a bit of a chat to him and says, look, Izzy, we're trying to promote a diverse and inclusive culture. We have a very public profile in Australian society. We've got a code of conduct which talks about making sure that we treat one another with respect and that we recognise diversity and promote inclusion. So it'd be really, really great if you wouldn't be making public tweets that may offend our code of conduct as to how we want our employees to behave and conduct themselves, particularly given you have such an extraordinarily high profile in Australia. So as I understand it, that chat was had and Izzy said, yep, no worries, gotcha. But then the conduct continued. And the particular tweet which brought the topic into sharp focus is what appears there as the 2019 tweet. Warning, hell awaits you, particular folk, including, for example, drunks, homosexuals, adulterers, liars, fornicators, thieves, atheists and idolaters. Repent, only Jesus saves. And then there was a bit of discourse back and forth in relation to that tweet. Now, I can tell you on a personal level, I was quite affronted and offended by that. Rugby Australia was quite concerned that there were people within the game who would be offended by it, that there would be sponsors who would be offended by it. But more importantly, that it was not consistent with Izzy Folau's contractual obligations, including under his employer's code of conduct. So as I understand the backstory, he was asked to take it down. And initially I think perhaps he said he was going to, but then maybe he didn't. But in any event, it didn't come down. And there was a question around whether disciplinary action would be taken as a consequence of failing to comply with contractual obligations, failing to comply with his employer's code of conduct. As I understand it, there was a disciplinary hearing and ultimately his employment was terminated, as we all know. Now, what happened next was that Izzy brought a claim. He brought a claim against his employer. And what he said was, leave aside what my contract says. Under the Fair Work Act, under section 772, an employer must not dismiss an employee for particular prohibited reasons, including religion. And what he said was, the real reason that his employment was terminated was because of his religion. So let's just have a look for one moment about what the current state of play is in New South Wales in terms of protections in terms of religion, bearing in mind that the suite of bills that I'm talking about are just that, they are bills. So in New South Wales, as it currently stands, we do have, as I mentioned, the Fair Work Act 2009, and section 772 prohibits dismissal for particular reasons, including religion. Now, just a note for our public sector employers playing along at home. This provision, section 772, is in the legislation under what's called our external affairs power. What that means is it doesn't rely on the constitutional corporation power, which underpins, say, general protections and other areas from which New South Wales public sector employers are ordinarily excluded. So be on notice that this provision has broad application across Australia. So that was the avenue that Izzy pursued. What we also have in New South Wales is the Anti-Discrimination Act, which includes a prohibition, thanks everybody for helping just then, on the ground of race. And then race includes ethno-religious origin, but to be clear, that provision can't be utilised when the alleged prohibition is straight up on the ground of religion. And then finally, under the Australian Human Rights Commission Act, discrimination under that Act includes religion, but here's a tricky twist and turn. The legislation deals differently with discrimination versus unlawful discrimination. Unlawful discrimination gives people an opportunity to go through the court system. So for example, you make a complaint to the Human Rights Commission, then if you can't resolve it, you can then take your complaint to the Federal Circuit Court or the Federal Court. By contrast, discrimination enables you to try and resolve the matter by conciliation. The Australian Human Rights Commission can table a report in Parliament if it makes a recommendation that you do a particular thing and don't comply with it. But the bottom line is that discrimination under the Australian Human Rights Commission Act doesn't give rise to an enforceable legal personal remedy. That is something that is set to change under the suite of bills because religion will be moved from discrimination into unlawful discrimination. So just back to Izzy for a moment. What he did was he went down the path of Section 772, arguing that the reason was because of religion. His employer was arguing, no, the reason wasn't because of religion, the reason was because you breached your employment contract. As we know, the matter resolved. The question is, would there be a different result in a brave new world, a different brave new world, where this legislation or these bills actually become law? All right. I'm just going to chat to my little friend here for a moment who's dealing with some of our technical difficulties. That's fine. I'm happy just to look at the ones up on the screen. Oh, I need to do that. All right, makes sense. I'll keep changing this then. I'll stop playing with my little buzzer and I'll play with those arrows. Sorry about that. All right, here we go. So let's talk about the religious discrimination bills. What are the objects? So the objects are to eliminate discrimination on the ground of religious belief or activity, equality before the law regardless of religious belief activity, and ensure, consistently with Australia's obligations with respect to freedom of religion and freedom of expression, and subject to specified limits, that Australians can make statements of belief. So on the face of it, seems pretty fair, doesn't it? But as this seminar unfolds, I will be posing this question: is it a shield or a sword? Okay, so let's talk about what does religious belief or activity mean. So, holding a religious belief or engaging in lawful religious activity, or not holding a religious belief, or not engaging in or refusing to engage in a lawful religious activity. So what we know is religious belief is not defined and engaging in lawful religious activity is not defined. but we do have a little bit of guidance from the explanatory memorandum to the bill, so let me talk you through. Religious activity will include expressing religious beliefs, such as through evangelising or making statements of belief which adherents to that religious group are required or encouraged to evangelise. Religious activities may include wearing religious dress, such as a hijab or a kippah or a kirpan. Religious activities may also include not engaging in certain conduct in accordance with religious belief, such as not eating meat or drinking alcohol. Now, as we will go through, the definition of religious activity is limited to lawful religious activity, and so there are some carve-outs about what will legitimately fall within that. Again, query whether they're enough. So, I'm alluding to the controversy, so let's go right there. I'll give you a moment just to read some of those headlines. Why don't I pick a few of my favourites? I was about to choose one which would have been quite offensive, so I better not. I won't choose favourites. You choose your own favourite. Okay, then why don't we go to some of the statements that have been made by particular human rights entities or proponents. And why don't I read these ones out, because it saves you doing it. So, the Australian Human Rights Commission has done quite a comprehensive submission in relation to both exposure drafts. And where we're actually up to at the moment is we're at the second exposure draft, and the Australian Human Rights Commission is still pretty unhappy, and I'll tell you why. So basically what they're saying is that, look, they're obviously supporters of enforceable protections against religious discrimination. Indeed, what they say is that prohibiting discrimination on the ground of religious belief or activity, indeed including beliefs about religion held by people who are atheists or agnostics, is consistent with and supports the tolerant, pluralistic nature of Australian society. But their concern is this. The Commission is concerned that in other respects, the bill would provide protection to religious belief or activity at the expense of other rights. The Commission considers that those provisions of the bill need to be amended or removed because they limit other human rights in a way that is unnecessary and disproportionate or are otherwise inconsistent with human rights law. So that's the Australian Human Rights Commission doing both. Then we have the Australian Lawyers for Human Rights. Now, I'm not going to read out that first paragraph because it's quite big, but where they conclude is the bill, and this is after the second exposure draft, the bill remains seriously flawed and is inconsistent with Australia's international human rights law obligations. They actually go so far as to say that it should be rejected in its entirety. And they further say this: the right to believe is an absolute personal right, exercised internally. But there is no absolute right to manifest or act upon one's religious belief externally so as to impact on others. Religious freedom does not mean freedom to visit harm upon others in the name of one's own religion. Former Justice of the High Court Michael Kirby says it actively fosters intolerance and will work to divide rather than unite. So therein lies the controversy. And as I say, fundamentally at its core, is this a shield to protect, or is this a sword to enable visiting harm on others? So why don't we talk about what are some of the more conventional provisions. So it starts off in a very conventional way. What it deals with is direct discrimination and indirect discrimination. Direct discrimination we're all familiar with, less favourable treatment on the ground of. Indirect discrimination is where a condition requirement, or condition, I think I've got that twice, which has the effect of disadvantaging persons who hold or engage in the same religious belief or activity in circumstances where that condition requirement or practice is not reasonable in the circumstances. So that formulation effectively mirrors how direct and indiscrimination work in every other piece of discrimination legislation that we have in Australia. So in terms of understanding how indirect discrimination may work in the current bill, this example is provided. Say, for example, there was a condition of employment that all employees are to attend meetings every Friday afternoon. This would disadvantage Jewish employees who leave early on Fridays to observe the Sabbath. Conventional. But there's also this concept of particular reasonable considerations and what will and won't be reasonable in the circumstances. I'm just being reminded to change my slide. So there's this concept of employer conduct rules and this question of employers being able to impose employer conduct rules such as in relation to standard of dress or appearance of behaviour. So an example of an employer conduct rule that may be reasonable is as follows. For example, a requirement that all employees involved in food preparation wear certain clothing for food safety purposes. That requirement may disadvantage persons who wear religious dress. However, if the reason for the requirement is food safety requirements, that may be a reasonable imposition of a conditional requirement. However, if the dress code prohibited employees from wearing any form of religious dress that was not related to food safety requirements or prohibited them from wearing religious dress at all times while at work, this could disproportionately limit the ability of employees to engage in their religious activity and therefore could be unreasonable. Again, pretty conventional application. I'm going to talk to you about the development of this concept of statement of belief, and this really does tie most heavily into effectively legislating to deliver a different outcome for Izzy Folau, as I see it. So, had he proceeded to run his litigation. So, Section 8.3 of the legislation has a provision which says straight from the get-go, there are particular conditions that will not be reasonable. So if we use a condition that you must comply with a code of conduct, just have that bubbling away in the background. Now, this particular provision only applies to relevant employers, and I'll come to that, so it doesn't apply at large to all employers in Australia. And what it's dealing with is a condition which restricts or prevents an employee making a statement of belief. Now, for a relevant employer, which is an employer who has revenue in excess of 50 million, this conditional requirement will automatically be not reasonable for the purposes of the test unless the employer can demonstrate that it is necessary to avoid unjustifiable hardship on the employer. Now, the explanatory notes related to this make clear that fear of an unjustifiable hardship is not sufficient, there will need to be cogent evidence of the actual unjustifiable hardship. So as I say, relevant employer has a particular meaning. So it means revenue for current, revenue of the current or financial year of at least $50 million. And this does not apply to the government. Before I talk about inherent requirements, you might be thinking, okay, so how does this apply? How then does this provision apply in relation to employers that are not a relevant employer? Basically what it means is that there is still an obligation to demonstrate that the conditional requirement is reasonable in the circumstances, but there's not this extra hurdle of satisfying the unjustifiable hardship defence. All right, so there's also, again, in line with conventional modelling of discrimination legislation, an exclusion in relation to inherent requirements. Discrimination will not be unlawful if it is necessary to ensure that the person can perform the inherent requirements of the role. For example, in the explanatory memorandum, an organisation hiring for a chaplain position may require that the chaplain be of a particular religious belief or activity. And then this one, and a catering company that services religious clients might require the staff involved in food preparation to be of a particular faith. The explanatory memorandum provides these requirements must be objectively related to the role. Employers cannot sidestep the obligation not to discriminate on religious grounds by deeming obligations or policies to be inherent requirements. And then it continues to say, the exception also recognises that employers should not be required to employ or continue to employ persons who cannot actually do the job for which they are engaged because of their religious belief or activity. For example, an employer would not be required to hire a person because their faith prevented them from adhering to health and safety requirements in the workplace. It has a particular meaning though in the context of statement of belief, and that is again for a relevant employer, so these larger employers, if the condition or requirement would not be reasonable for the purposes of Section 8 in the indirect discrimination test, it cannot be an inherent requirement of the role. All right. Another provision in the Act concerns statement of belief, and what this says is a statement of belief in and of itself cannot constitute discrimination. So this is Section 42, and basically what it says is making a statement of belief is not discrimination unless it would likely harass, threaten, intimidate or vilify, or it counsels or promotes a serious offence. And then here's an example in the explanatory memorandum for you. A statement made in good faith by a Christian of their religious belief that unrepentant sinners will go to hell may constitute a statement of belief. However, a statement made in good faith by that same person that all people of a particular race will go to hell may not constitute a statement of belief, as it may not reasonably be regarded as being in accordance with the doctrines, tenets, beliefs or teachings of Christianity. So what you will see is that particular beliefs that are said to have their genesis in doctrines, tenets, beliefs or teachings of the particular religion will be protected statements of belief. And I'm just going to again talk about a couple of points from the explanatory memorandum which give us a little bit of guidance as to how these might apply. I'm just checking my clock, everyone, because there's no clock at that end of the room. Excellent, plenty of time. Sit back, relax. So section 42 provides a safeguard, we're told, that statement of belief cannot be used to protect statements which are malicious, would harass, threaten, seriously intimidate or vilify a person or group, or which advocate for the commission of a serious offence. And then what it goes on to say is this provision will mean that a person cannot be found to have discriminated against a person under any discrimination law for merely expressing their genuinely held religious beliefs in good faith. This could include, for example, merely stating a biblical view of marriage or an atheist view on prayer. So this, for example, highlights one of the tensions in this suite of reforms, is whether we're basically creating a hierarchy of rights. Is this legislation a shield to protect or a sword to hurt? All right. Now, there are express exceptions for religious bodies. So these are express carve-outs or different rules of the game for religious bodies. So I'll give you a couple of the examples that appear in the explanatory memorandum in relation to these particular provisions. So it would not be unlawful for a Jewish school to require its staff to be Jewish and accordingly refuse to hire someone because they are not Jewish. This would very much upset one of my very good friends who is actually a Christian at Moriah College. An Anglican public benevolent institution could institute a policy which required its employees, including volunteer workers, to uphold and act consistently with Anglican doctrines and teachings at work, or refuse to engage a volunteer worker that refuses to engage with the doctrines and teachings. And then it gives this example: an Islamic organisation hiring staff may prefer applicants who are Islamic or require a certain proportion of their staff consist of Islamic people, provided this was in good faith and in accordance with the doctrines, tenets, beliefs and teachings of Islam, or to avoid injury to religious susceptibilities of Islamic people. You'll see that this part is not qualified by any inherent requirements defence. So who's a religious body? A religious body is an educational institution conducted in accordance with doctrines, tenets, beliefs or teachings of a particular religion. A registered benevolent institution conducted in accordance with doctrines, and an other body conducted in accordance with doctrines. Just a tip that it doesn't apply to hospitals, aged care facilities or accommodation providers. So, why don't we now bring it all back to, had this legislation been in place, would Izzy have been protected? So let's just step through. He would say that he was merely communicating a statement of belief, so that he was exercising a religious activity. So what we know is the bills seek to prohibit discrimination directly on the ground of religious activity. So if all he was doing was exercising his right to engage in a religious activity and then he was terminated, would he have been protected under the legislation? Or would you still argue, well, that was not the reason he was terminated. The real reason that he was terminated was because he failed to comply with a conditional requirement as set out in the Code of Conduct. But then what we know is there are particular rules under the legislation about employer codes of conduct. So one of those rules would have applied, I assume, to Rugby Australia, because I'm going to assume that they have revenue in excess of 50 million. So then what we know is the legislation would expressly deem that the code was not reasonable unless Rugby Australia is able to demonstrate that failure to comply with the code would result in an unjustifiable hardship. So again, what do we know? Well, in the background, we're led to understand that a lot of pressure was brought to bear on Rugby Australia by Qantas as one of the largest sponsors. We don't know what that conversation was. Certainly we do know that Alan Joyce expressed the view that he didn't want to sponsor something to get involved in controversy. So perhaps what we know is that Qantas threatened to pull sponsorship unless action was taken. For the purposes of the unjustifiable hardship test, what we also know is that to rely on it, there needs to be cogent and clear evidence of actual loss, not threatened loss or fear of loss. So I think it's an interesting question that remains. In any event, what's our current status? Our current status is it's still a bill. It's been floating around for quite some time. There's been a first exposure draft. There was a consultation period. There was then a second exposure draft, and then submissions on the second exposure draft have now closed. What we know is during this second round of consultations, there is still significant disquiet amongst, in particular, human rights organisations about the operation of the bill. So as it stands at the moment, it's not law. We are still in a bit of a state of flux, and it would be fair to say it's a bit of a wait and see. So on that note, I will now throw to my fine colleague Jade, who will be talking to us about sexual discrimination and harassment and other issues. Thank you, everybody. Oh, thanks, Nick. Nick just clapped.
Thanks, Amber. Thank you, Nick. And since I cannot be trusted with too much technology, I'm handing over the clicker responsibilities. So as Amber said, we are going to be shifting gears a little bit and talking about sex discrimination and sex harassment. And this has received, understandably, a lot of attention lately, especially after the Me Too movement reached a lot of public attention, and then also some very high-profile workplace sexual assault and sexual harassment cases, such as Weinstein in the States. So following up with that, I just want to briefly touch on something that it's not a new concept. It has been around for quite a while, and that's the issue of vicarious liability. So in a nutshell, as employers, we can be held liable for conduct that occurs in the workplace or in connection with employment. And it will be taken, sorry, excuse me, it's not corona, I promise. I'm not dying yet. So essentially, unlawful conduct by an employee can also be taken to be conduct performed by the employer as well, unless it is established that the employer took all reasonable steps to prevent the employee from doing the act in question. And this is not a new concept at all. However, it has been brought back into the spotlight, and there was a case that came out earlier this year, I believe it was just in February, that really brought some attention back down on it. In this case, we had 2 employees. One alleged that she had been sexually harassed by her co-worker, but she also claimed that her employer was also vicariously liable. And in the hearing on this matter, the employer relied on the fact that they had developed a working with respect policy and conducted training sessions, and they contained fairly extensive or substantial notes on sexual harassment in the workplace. And in the initial decision, the federal court agreed and found that, yes, she had been sexually harassed by her co-worker, but did also find that the employer had taken all reasonable steps and wasn't vicariously liable. As you can imagine, since we're talking about this today, on appeal, that decision changed. And here, the full federal court did actually find that the employer was vicariously liable because they hadn't taken all reasonable steps. Yes, they had their policy. Yes, they had the training slides. But the full federal court found that the employer in this case hadn't been able to put on any evidence to show that they'd explained the meaning of zero tolerance to their employees, or had explained that there could be disciplinary action taken as a response or as a result of sexual harassment, and that employees who had attended the training had actually had the policy explained to them. And they really, just to quote them, did actually put this quite nicely when they said that it's unnecessary for the employer to take all steps necessary to prevent the employee or agent from doing the relevant act. What must be taken is that all steps that are reasonable to take. And the focus is upon preventative steps taken before any relevant act occurs. So certainly you don't have to do everything, but you do have to do everything that is reasonable. So what should you do? We're not asking you to follow your employees around all the time and monitor them. That would be creepy, no offence. I don't want Amber hovering over my shoulder all day long, as fun as that would be. So what should you do? Certainly implement a policy. Have a policy, make sure it is robust, make sure it does actually cover how to manage a claim of sexual harassment and also what will happen, what disciplinary steps may be taken, and also continue with education and training programs. Have presentations such as this one, toolbox talks, annual retraining programs. I know we roll our eyes at them, but they are useful, and also keep evidence of these. Appropriate supervision is important in the workplace. Yes, hovering over the shoulder may be a bit much, but actually making sure that you do have managers there, that they are engaged and they are part of the workplace and they are visible. And we should also have effective complaint management systems. It's not enough to just put in a complaint and essentially have it sit in limbo. You need to engage with it, to be part of it, to consider it and to actively act upon it. And they shouldn't be received with any sort of scepticism. Your staff should feel comfortable coming forward, that they can actually talk to you and that they will be believed. Following on from that, there's also acting on informal reports as well. Don't wait for a formal response to come in. If somebody talks to you casually over coffee, start acting on it. You do have a culture to maintain here. And of course, take any risk management action immediately. Don't wait for this one to sort of blow up in your face to actually respond to it, because worker safety is still paramount in this case. Now, as James mentioned at the beginning, the AHRC has recently released a report, the Respect at Work report, on the National Inquiry into Sexual Harassment in Australian Workplaces. So quite a long title and quite a significant report. Now, the previous report by the AHRC was done back in 2018, and that was a very statistical and detailed, very thorough report. And some of the conclusions and results that they found were quite disappointing, unfortunately. So in 2018, they found that 33% of people in the workplace in the last 5 years had experienced some form of sexual harassment, with women, people aged under 30, LGBTQI workers and Aboriginal and Torres Strait workers being some of the groups that are more commonly targeted. Some of the harassment still includes verbal comments and jokes. They still aren't funny, people. Sexually explicit pictures and physical conduct and contact, so leering over shoulder. Sorry, I'm really going with Amber leaning over my shoulder a lot today. Sorry there. So things...
Is there something we need to talk about, Jade?
We'll have a discussion later. So that still is occurring, and I'm really sorry to say this, the majority of harassers are still male. That stereotype is still alive and kicking. I know, James, I'm sorry. It's still alive and kicking. I'm sorry. So this particular report, the Respect at Work report, didn't redo that statistical analysis. They recommended that be done every 4 years. So come back to us in 2 years' time and we'll have a look at this again. However, they did make some very interesting recommendations, including 2 that we've got up on the screen here. So the first one is that the Sex Discrimination Act should be amended to include a positive duty on all employers to take reasonable actions and to promote measures to eliminate sex discrimination in the workplace. And the AHRC would be kind of the enforcers for that. So it's very, very similar to the safe work obligations that are already in existence in WHS legislation. So think of AHRC becoming kind of a safe work in the discrimination space. It's also supported by proposed changes to the WHS regime as well. So, for example, amending the model regulations to address psychological health, and also with Safe Work and WHS regulators also undertaking training and education on the drivers and impact of sexual harassment so that they can be informed in their own work when they actually look at an investigation. And the second recommendation that we're going to briefly touch on is the one that I find very interesting. And that's introducing something very similar to a stop bullying order, except in this case it will be a stop sexual harassment order. So it's really trying to get at it very early on, and essentially it's almost a name and shame, both of the harasser and the employer as well. So in this case it would be very much the same as a bullying complaint. You can make a complaint, orders will be put in place to address sexual harassment in the workplace. This is also going to be, if it is accepted, so the recommendation is that it's also coupled with including sexual harassment as a valid reason for dismissal, including for serious misconduct as well. So it's really looking at shifting the obligation onto the employer, both in a positive sense and also in a very public name and shame. So very much watch this space on that one. It could be quite interesting to see how we respond to this. And just to wrap up today's kind of a variety show grab bag of discrimination and harassment, we just want to very briefly discuss the concept of criminal record discrimination. Now that gorgeous gentleman up on the slide there is supposedly Al Capone in 1932, according to Google. However, I don't know that photos were that good, but let's just go with that one at this stage. So, criminal record discrimination, not entirely a new concept here. However, there was a change late last year. So in October of last year, the AHRC regulations were changed so that the definition of discrimination when it comes to criminal records was changed to read that it is now any distinction, exclusion or preference made on the ground of an irrelevant criminal record. So before that, it had not been unlawful for employers to discriminate on the basis of a criminal record if the record impacted on the performance of the inherent requirements of the job itself. So again, we're going back to this inherent requirements. Now this change came in because there started to be a little bit of a tension between the AHRC and employers, arguably society, Attorney General, about what the inherent requirements actually captured. And this was nicely demonstrated by 3 decisions that came down in 2018 from the AHRC about 3 different types of criminal activity. So the first one we have actually involves Suncorp. In this case, a conditional job offer was made to somebody who is going to be in a 1-year contract position, subject to criminal record checks. Those checks came back and found that he had actually 3 charges against him: use of carriage service to access child pornography, possession of child pornography, and then failure to comply with reporting requirements. And Suncorp rescinded that offer, saying that as part of his inherent requirements, he would be accessing the internet, using technology, and would have access to confidential information. The AHRC took a very different view on this and found that that wasn't sufficient. There wasn't enough of a tie between the inherent requirements of the role and the conduct, the possession of the child pornography and the failure to report. And they actually recommended that Suncorp pay a fine or pay damages, in this case of $2,500. That copped a little bit of attention from the then Attorney General, Kristen Porter, who said in a radio interview that the idea that Suncorp suffered a law and a decision that told them that they couldn't make that exercise of their own discretion seemed to us to be pretty strange, if not a bit ridiculous. So yeah, we changed the law. And here we are. The other two cases that sort of brought this up as well was one involving DFAT, the Department of Foreign Affairs and Trade, and that's the second one there. And that's endangering the life of a domestic animal and damaging property. So in this case, the employee was actually engaged by a labour hire company on a one-year contract there. While he was employed in that role, he was required to maintain a security clearance. However, at the same time, he also had an issue with a neighbour's dog. He was woken at 2:30 a.m. and really lost his cool with it and threw a packet of rat sack over the fence to silence the dog very permanently. And when that didn't work, he then threw a 1 litre can of paint at the dog. The dog was fine. The dog was not injured at all from either one, but the paint can did damage the dog's dog kennel. So he was actually placed on a good behaviour bond for endangering the life of the domestic animal and damaging property. He self-reported to the police station, but in this case he did not report to his employer that he had been placed on a good behaviour bond, and that was part of his maintaining his security clearance. And in this case again, AHRC found that DFAT had engaged in unlawful discrimination by encouraging the labour hire company to remove him, and DFAT was recommended to pay just over $120,000 in damages, including lost salary here, so a hefty one in that case. And finally, the last one we have up there is assault occasioning actual bodily harm and marijuana possession. In this case, the employee had actually been employed to work as a mobile speed camera operator, and RMS required that all employees basically be of good character in this case, and also be able to maintain calm in potentially a hostile situation. We all love mobile speed cameras, so fun times there. And in this case, the offer was again rescinded, partially because they thought that the person may not be able to maintain their calm and was not of good character. And the AHRC again disagreed. So in light of all three of these particular cases, the law has been changed and it's now down to an irrelevant criminal record. So the question is, what is irrelevant? In this case, it's really going to be determined on a total case-by-case basis. It will depend on the nature of the offence. So, for example, as a lawyer, if I'm found guilty of committing fraud, that's going to be a big one. If I cop a speeding ticket, unlikely. Can't really see that one. Time since a conviction, are we talking last year? Are we talking 30 years ago? How many convictions? Do we have an ongoing pattern? Is it a one-off? The nature of the employer's business. So again, accounting firms, law firms have a different style or different level of trust for us. And also other considerations. Who are your clientele? Do you have any statutory obligations? So again, very much so watch this space. I get all the watch this space part of this talk today. So and wait to see what happens with this one. But it has changed it a bit, where you do actually need to consider what is an irrelevant criminal record or criminal history. So with that, we come to the part where normally we would have a great discussion about hypotheticals and what this does actually mean for you. Unfortunately, in coronavirus times, we do need to do this online. But please, by all means, feel free to call us, to email us. We have our details up there, or any other member of our team. And otherwise, we'd just like to say thank you so much for watching this. We hope that you've enjoyed it. Stay safe and stay healthy, and we'll be back in touch with you very, very soon. Thank you.